Hello and welcome to Questions That Matter. This is a brand new show from TrustBridge where we talk about all of the important and interesting questions that our team is working on. Today I have with me my colleague Natasha. Natasha and I have written a paper together about tribunals, and more specifically about the Appellate Tribunal for Electricity, power sector players in the state of Telangana, the state's Electricity Regulatory Commission, and the High Court of the state. Now, tribunals were set up for a number of reasons. One of the reasons that's talked about most often is that they were to reduce the burden on high courts. In the case of the Electricity Tribunal, there was a Supreme Court observation which led to the establishment of the tribunal. And one of the felt needs was for technical expertise because the sector demanded it. And so the APTEL has both judicial as well as technical expertise, and this is why it is preferable that appeals from the ERC's orders go to the APTEL. However, we noticed a set of curious incidents sometime around 2021, 2022, and what was happening was, in the case of the Telangana ERC, challenges to the orders of the Commission were not going to the APTEL. Instead, most participants preferred to file writ challenges to the orders of the ERC before the state's High Court. And to put this in perspective, in the period that we studied, there were 85 writ challenges as opposed to only 12 appeals to the APTEL. Now, this is not a desirable situation. We've talked about the reasons for the establishment of the tribunal, and bypassing that expertise by going to the high courts undermines the very reason that the tribunals were set up. So what did we find? What is the data that we used? And what can we learn from this set of findings? These are things that we've talked about in the paper and which we want to present to you today. Right? So Natasha, congratulations on the release of the working paper.
To you too.
Thank you very much. Now, take us through this. So let's start by talking about what the data set was that we worked with.
So we looked at the annual reports, and we looked at the annual reports for a period of 8 years, so 2014 to 22. And we realized that there were many writ petitions and writ appeals going to the Telangana High Court as opposed to the Appellate Tribunal for Electricity.
All right, so just so that I understand this a little better, you said there are writ petitions and then there are writ appeals. So would I be right in saying that if I were to challenge through writ an order of the ERC, I would be filing a writ petition. And if I was unsatisfied with the decision of the High Court in that petition, then I could even file an appeal, and that would be a writ appeal. Is that correct?
That is correct. So we took a sample set of all of these writ petitions and appeals. And for the writ petitions, we took a sample of about 22%. For those 8 years, and that translated to about 180 writ petitions. We also looked at the number of writ appeals. We created a subset, and again, about 180, 181. The surprising part was that the number of writ appeals that we had was much more than what the annual reports said. So the annual reports only said 72, and we got 181, which might not be all of them.
We're talking now about the annual reports of the ERC. And so what we found was that the number of writ petitions reported in the ERC's annual report is lower than the ones that we actually found in the High Court.
That is right.
I see.
Yeah. And we then wanted to see whether these writ petitions and writ appeals should have gone to the High Court, or could they have just gone to the APTEL. And to understand a little bit of that, we had to look at the grounds of judicial review. So when can matters like this go to a high court? In order to understand whether these matters fell within that framework, we had to look at the issues involved in these writ petitions and writ appeals.
I see. So before we jump into the issues, I think it might be useful to try and understand what the scope of judicial review is. You mentioned that, and I think we know that there are broadly 3 or 4 grounds when judicial review of something like an ERC order might be permissible under Indian constitutional and administrative law. So let's say there is some illegality in the order. There is a procedural impropriety. There's something blatantly wrong or violative of the fundamental rights, or there's a challenge to a law. these are the sorts of situations when you may approach a high court and the high court can exercise its powers of judicial review. But by and large, for want of a better term, substantive technical matters that are the bread and butter of the ERC and for which the APTEL has been set up should be going to the tribunal and not to the high courts.
Yeah, and we can take a second and think about why that is, right? So, one of the reasons that the grounds for judicial review are limited ties back to why tribunals were created in the first place. So, let's take some burden away from the high courts. And for substantive issues, APTEL has a technical member, which means that they have somebody with expertise in the electricity sector. That's not always the case with high court judges. So substantive issues are something that the APTEL should look at.
And so what did we find in our data set? What sort of issues were going before the High Court?
So we found 5 broad issues. And I'll just list them out and then talk about each of them. So the first was jurisdiction. Then we found a couple of matters relating to duration. We saw a challenge to the validity of the regulations. We saw procedural irregularities, and we saw substantive issues. Now, going one by one, so jurisdiction, matters relating to jurisdiction kind of made sense to us because of the reorganization of Andhra Pradesh.
That's right. I think it's important to point out that 2014 is when a separate ERC was established for the state of Telangana. This is after the reorganization of Andhra Pradesh and Telangana around that time. And so there were many questions about which ERC you should go to. Should you go to AP? Should you go to Telangana? And so that set of jurisdiction questions makes sense.
That's right. The other set of issues that kind of made sense to us was duration, because there was the COVID-19 pandemic and that impacted a lot of the tariffs and subsidies, and therefore we see duration as an extraordinary event, and it makes sense to have gone to the High Court, perhaps. Now the challenges to the validity of the regulation. So one is that it's within the permitted scope of judicial review. And the second thing is this is just one matter. No writ appeals, just one writ petition. So it is also limited in its scope. The fourth issue we saw is procedural irregularities. This was more matters than is ideal. So we saw about 11 to 12% of our writ petitions and writ appeals relate to procedural irregularities.
I want to just take a moment to underscore that a little bit. You know, 11 or 12% in and of itself may not sound huge, but we're talking about procedural irregularities.
Right.
These are the most straightforward set of problems to identify, potentially the easiest set of problems to solve even. And yet you've got 10 in 100, 12 in 100, where there are these simple lapses as a result of which the ERC's orders are being undermined and challenged before the High Court.
Yeah, and we looked into that, right? We looked into why this is happening, and we realized that for about 3 years, APTEL didn't have a legal member. So just the way a tribunal has a technical member, it also has a legal member. And courts, the Supreme Court in particular, has repeatedly reiterated that you must have a judicial or a legal member because they have legal knowledge, so they can ensure that certain procedures are complied with.
And so this entire bunch of challenges could have been avoided if we just stuck to the requirement and had those appointments been made in time.
Yeah, that's correct. Moving on to our last issue, which concerned us the most, substantive issues.
These are matters that should, by all rights, have gone from the ERC to the APTEL, but instead went to the High Court.
Correct. And if you think about it, a substantive issue like determination of tariff or subsidies should be dealt with by the APTEL, right? Because at some level they require technical expertise. So perhaps the APTEL would be better placed to deal with such an issue. And the reason it's so important is because about 53% of our writ petitions and 58% of our writ appeals concern substantive issues. So it did take up a substantial amount of the High Court's time, and once again, could have been avoided.
Understood. And are there any more conclusions that jumped out to us, something that we saw in the data?
So we realized that this is not an issue that's limited to Telangana. And at some point, we should look into why this is happening in other states. But between 2019 and 2020, this also happened in Odisha and West Bengal. They also had more writs than appeals to the APTEL. So it's worth looking into why that's happening.
Understood. And I think that's a good idea. If we're able to extend this work to other states, perhaps create some kind of a useful comparative matrix involving all of these states, maybe we find that certain ERCs are performing better in certain aspects, and there are lessons to be learned from these ERCs that other ERCs could possibly employ. It's been great working on this paper with you. I'm looking forward to extending that work to other states.
Yeah, me too.
The link to the paper that we've been talking about will be in the description below. Thank you so much for watching. Please do keep watching these videos, and we'll bring more and more of our work to you very soon. Thank you.
Thank you.